Thank you both so much for joining us.
Pleasure.
We've been told that the work of the Commission has handed the sector a framework for a decade of hard work on this topic. Let's talk about how you came to see the issue yourself, starting with you, Sarah. What was your conclusion about how well the legal framework as it exists today deals with the issue of elder abuse?
I think the recommendations suggest that the conclusion we came to was that it dealt with it in part acceptably, but there was a lot more work that could be done to tighten particularly reforms and regulations around the aged care sector and around the way enduring documents are dealt with.
And then what about you, Matt? What was your conclusion overall?
I think what we heard throughout our inquiry were some fairly egregious examples of elder abuse, whether they be within families or in the aged care sector. And naturally people's responses to those often quite challenging issues is, someone's got to do something, this has got to be stopped. And what we needed to do as a Law Reform Commission is take a step back from those stories and look at what is the role of law? What can law do to respond to these situations, to prevent these situations? And what are things that law isn't so good at preventing? It's a blunt instrument. Where are the societal and cultural changes that are needed? And really trying to ensure that we had a finely calibrated response.
We've heard stories, Sarah, of people putting grandma to live in the garage without toilet and shower facilities. Call the police. That's illegal. Isn't it as simple as that?
It could be as simple as that, but will they call the police and will the police act? The police have got to see evidence of an assault, evidence of systemic abuse. It's more likely in that sort of situation that the civil system, it's negligent behaviour rather than criminal behaviour. And again, we've heard from a range of stakeholders, and we heard again this morning in the plenary session, that families don't really like to involve law enforcement in many of these cases. And certainly the elderly who are vulnerable don't want to be seen to be taking their children to court over these sorts of things. That's a matter of enormous shame for them. So there's got to be different ways of dealing with those sorts of situations. But I come back to Matt's point. This is about ageism, and it's about a cultural response. And dare I say it, it's about, we heard today that of the spike since about 1991, and I'd link this to the cult of the individual. We are now so focused on our individual needs and wants that we've forgotten about our broader family's needs and wants and about the broader society's needs and wants.
Thinking back to the summary that I read of your recommendations, there's some work around a register of enduring documents. That was one of the recommendations. What does that mean?
That would look like an online registration system where a document is lodged and recorded, so that if a financial institution 5 years after the original document is asked to open another bank account, transfer money or what have you pursuant to a new enduring document, there is a means of checking whether there was an already existing document. Has it expired? Does this one now come into existence after a person has lost capacity? At the moment, there's no possible way of a financial institution to check the existing state of the documents that might be in place for the individual.
So Matt, this is where I'm operating mum or dad's bank account and I wave a piece of paper at the teller and off I go. Where's the vulnerability there?
Well, there's a real question, I think, as to whether or not these documents are seen in society as a blank cheque. There's a lot of reticence around challenging the authority of someone with an enduring power of attorney. Are they acting in the best interest of the person? Are they acting in accordance with that person's wishes? And I think what our reforms, whether it be the register or the safeguards, do, they work on two levels. The first level is to give the older person confidence that if they do lose capacity, they have a certain degree of control over that power of attorney, that they don't just hand over a blank cheque. They can, for example, put in exclusions so that the house can't be sold, so that what they want their son or daughter to do is to help them with the day-to-day finances. They don't want them, absent talking to the rest of the family, making big financial decisions. So we want to give the arrangements that rigour that gives the older person confidence that there are limits. And secondly, we want organisations like banks and financial institutions to have the confidence that these documents are being used appropriately and in accordance with their terms. And at the moment, because they are made privately and there's no register, it's very difficult for a bank to check, for example, if they've been handed an enduring power of attorney. Has it been revoked? Is it the most current? There's no way of knowing that. And so they have to just simply act on the document that's presented to them.
Does there need to be a law, a specific law, crime of elder abuse, whether you want to characterise that as physical or financial or psychological or emotional or whatever? Does that need to be a specific crime?
We didn't recommend that. I think there's probably enough rigour in the current criminal laws to cover all of those instances of which you speak. I think the question is, how do we communicate and educate the public that these laws are already in existence, and how do we train law enforcement to recognise the instances of abuse that fall within the existing criminal laws?
I think that goes back to your first question in terms of what can law do and what can not law do, because what we did throughout this inquiry was we look really, really closely at all of these examples of elder abuse that we're hearing and analysing, is there a criminal law that is applicable to that conduct? Are there actually any gaps in the criminal law? And the view that we came to was that no, for every example of elder abuse we've heard, there is a criminal legal response. But the criminal law is a very blunt instrument. You need to be able to prove the crime beyond reasonable doubt. When we're talking about, as Sarah said, family relationships, people can be unwilling to testify against their family members. When you're talking about an older person who's lost capacity, there are real evidentiary issues that make it very difficult to prove beyond reasonable doubt. So from our perspective, what isn't necessarily, whilst it may intuitively make sense, elder abuse is a problem, we need an elder abuse law, we would say that we've already got the laws in place. What we actually need is better community awareness and a better community response to provide that protection.
If you want to empower older people and not infantilise them, should they be allowed to consent to some form of abuse from their family members because they say they only have a few years to live and they would like to retain a relationship with their son or daughter, or indeed their grandchildren?
I think that question needs to be teased out a little bit, because I think what we need to think about also, what are the choices that older person has? And it's very easy to say, oh, well, they want to see the grandchildren because if they don't tolerate the abuse, then their son won't let them see the grandkids. Therefore, that they've made an informed choice to put up with that situation. And it's like, well, let's actually just interrogate that a little bit. Do they have all the information available to them? Do they know that their son's threat is hollow? Does the person have other supports that enable them to assist them to make the right decisions? And I think we need just to interrogate the context in which the older person's living. And at some point, yes, we do need to allow people to make decisions that involve risk, that involve choice. But to simply say, oh, well, the person's chosen abuse, I think it's very rare that you would say that in an ideal world that's the choice they've really made.
I think there's a point where you cannot consent to abuse that is criminal. But at what level of abuse, fully informed, can you give your consent? That's the question, without infantilising the older person.
And then you get to issues of mandatory reporting and
Yes.
going outside of the family. What were some of the observations and recommendations you made about how institutions, particularly aged care residential institutions, should deal with circumstances that might give rise to elder abuse?
Well, there was a recommendation around mandatory reporting within aged care settings, but again, we know that is such a small proportion of the population where the abuse takes place that it's only going to go a small way towards resolving that issue.
I think the aged care sector is a particularly unique set of circumstances where perhaps some form of reporting is required. And I think when you look at our recommendations in the aged care space in respect of that reporting, you've got to look at a sector where today over half of those in residential aged care have some form of cognitive impairment. We are talking about some of the most vulnerable people living in institutions, and we also know that with an ageing population and on the other side the push to have more people stay at home, that the concentration of very vulnerable people with significant impairments in aged care will grow. And it's in that context where we have suggested in our recommendations that there needs to be a mandatory reporting and response, given the particular vulnerabilities and the challenges for those people in those settings in seeking redress.
So beyond dealing with those aged care facilities and dealing with the document register to give financial institutions a better idea of how to do what the older person or their client, their customer, intended for them to do, what are the other areas that you identified for substantial reform?
In legal terms, one of the other reform proposals was around giving jurisdiction to the tribunal level of the judicial system to deal with matters that ordinarily would require the attention of the Supreme Court, so particularly around equitable remedies. In the example where a son is allowed to live in the house and transfers the house into his own name whilst mum's living there, and then there is an issue of who holds the beneficial interest in the property. Those sorts of matters ordinarily required a Supreme Court level judge to deal with the matter, and one of our recommendations was to move that into the civil and administrative tribunal level to reduce costs and enable accessibility.
I think one of the other important areas is in terms of banking. Banks often are the place where older people present, and there are an opportunity. They're the last group that still do face-to-face banking quite frequently. There is an opportunity for banks when they see transactions that don't look right, or they see that their customer seems nervous or out of character, to report. And I think there's a lot of concern in the community about privacy, and I think what we've really tried to do in that space is say, yes, privacy is important, but there's an overriding obligation if you think that a crime has been committed to report that. And it's that sort of early intervention that can be really useful in terms of reducing the size of any loss when we're talking about financial elder abuse.
Sometimes in institutions in Australia, historically, leaders have had trouble defining what's in the private realm to be dealt with internally and quietly, whether that's in the family or within a church organisation dealing with allegations of child sexual abuse, and what's actually in the public realm. This is not a matter that you're going to deal with privately in a rigorous way or indeed sweep under the carpet. This is an instance where you need to call the police. Do you detect a similar blurring of that line and confusion on the issue of elder abuse?
Absolutely. And you make a very good point. For example, why is there not mandatory reporting from GPs of elder abuse as there is for children, for child abuse? Again, the older generation is probably the last standing generation that's regularly going to church. If church officials notice something going on, they have no obligation to report. They do have mandatory obligation reporting requirements in relation to any child abuse that they pick up. So I think the same issues arise here, but I think the difference is the autonomy and dignity of the older person that puts it in a different realm to the manner in which we deal with mandatory reporting for children.
I think in terms of that old adage that police don't deal with private matters, they don't deal with public matters, I think in terms of elder abuse, the police are doing some great work. It's early days, but if you look at, for example, in Victoria, they've got elder abuse networks that have a range of professionals, including police officers. They have those networks, and I think they are doing that work to actually take it out of what historically would have been seen as a very private matter into being more public. But as I said before, there are a lot of challenges in policing this space, particularly because of just the nature of the personal relationships.
And as part of your inquiry, what were the models or practices and where were they that you thought that's best practice? There it is there.
Well, I think there was some reference to the Ontario system, and again, this morning we've heard a lot about what various provincial Canadian governments have been doing in relation to elder abuse, or as they prefer to frame it, healthy ageing.
I think the parts of the Ontario matter that are interesting are the fact that it's about getting a whole of government approach. It's about saying every agency has a role to play and that ensuring that there aren't any gaps. And I think if you look at some of the work that's coming out of Victoria in response to the Royal Commission into Family Violence, again, that is looking at holistically what are the different agencies involved, what is their role, and ensuring that if there is an older person who needs support and advice, that they find that advice. It's not, oh, well, that's not our business, that's someone else's, that the whole system as a whole responds to that one person. That's really important.
Thank you both so much.
Thank you.